California, the forms that you must fill out to get an expungement are called PC 1203 forms. There are blank forms which you can fill out by checking off different boxes. You will also need to fill out a blank order of dismissal forms. To expunge a misdemeanor, file a petition to dismiss a misdemeanor if you complete probation. If you haven't completed probation, then you must file a motion to terminate probation or a petition for dismissal if the motion isn't granted. The form should be available at your local courthouse, or you will have to draft it yourself. To expunge a felony, you first need a file under to reduce to felony to misdemeanor. Your local courthouse may have a form, or you will have to draft it yourself. You will also file a petition to dismiss a misdemeanor or petition to dismiss a misdemeanor. The form for felony reduction are eligible at your court location. In the case of a felony in which you were sentenced to prison time, but instead served time to a county jail, file under PC 1203.41. Okay. Filing for expungement. How we can file? We should go to the criminal court. Number one, find a lawyer if possible while you can represent yourself. You may have great success if you find trained legal representation. You might be able to have a public defender while the paperwork on your behalf. You should contact the lawyer from your original trial and find out whether you can find the probation for you. If you cannot get a public defender and do not wish to use a lawyer from your original trial, or if she's unavailable, find a new lawyer. If you could ask friends and family for referral or search online or relevant There are many different kinds of a lawyer out there. Be sure that the lawyer you retain is a certified specialist in criminal law who holds a license with the California bar. Get and fill out 2 forms. Download the necessary forms from the court website or get them from the court in prison. Write them out completely and accurately. You may want to to attach any document you want to show to the court. These documents can include proof of foreign or you may want to attach a document you want to show to the court. These documents can include proof of probation or rehabilitation completion, character, reference letter, and community service. Completion paperwork are also often included. They are not required, but may be helpful. File the forms, 3. File the forms and pay the fee. File the forms with the court where the offense occurred. Go to the office of the clerk of court with your complete form and the filing fee. The filing fee variable based on the case, on the county where you were convicted and whether you were convicted of a misdemeanor or a felony. For example, San Diego County charged a filing fee $60 for a misdemeanor and $120 for a felony. In the area you live by to court website. Application fee is misdemeanor $60. Felony is $120. Okay. 5-minute break. 14 page. Prepare for your hearing. After you file your paperwork, the court will schedule a hearing. It will be to a judge to decide whether to grant your expungement. Before this hearing, it is a good idea to consult with an attorney about how best to prepare. Before the hearing, the court will notify the prosecutor in your case so that they can file objection to the application for expungement. The prosecutor's objections will set forth the specific reason why they claim the expungement should be denied. You will want to have responses prepared to any foreseeable objection. Prepare a statement for the court and make copy of all documents and evidence related to your case that you wish to submit. 5. Attend your hearing. Show up on time. Dress appropriately and behave respectfully. Address the judge by his or her formal title, judge or your honor. At the hearing, the court will either grant or deny the expungement based upon the evidence and argument presented. There are several things the court will consider when making this decision, such as whether you have been charged with or arrested for any more crimes, your behavior since the offense. This including your behavior, ability to keep a job and pay your bill and debts. It also includes education or job training you completed. Judge often will consider community involvement like joining a church or volunteering to any argument based by the prosecution, whether the government has an interest refile be necessary, if necessary. If the judge denies your petition, ask what you need to do to get your conviction expunged. The judge will tell you why he or she denied the petition and what you need to do to get the petition granted. After listening to the change that the judge suggests, make any necessary change you can. You may refile your petition 6 months after the original denial, after you have made the change recommended by the judge. Seeking pardon or a certificate of rehabilitation. 1. Gather the collect forms. If you do not qualify for expungement, then you should seek a pardon or a certificate of inhabilitation. To ask for a direct pardon, download this form. To seek a certificate of rehabilitation, fill up a form at your county courthouse. You have the right to an attorney assistance. If you want a public defender to help you, then you can request one. 2. Fill out the forms. The forms will ask the information about your convictions and the punishments. You must list them all. Keep a copy for your record. 3. Find the forms. You will have to file the forms. The application for certificate of rehabilitation will be filed with the clerk of the country in which you reside. There is no filing fee. At the same time, fill out and file a notice of filing, which is conform forms available in the pocket. You must give this to the clerk. Four, get the materials for the hearing. You should be prepared to present evidence that you have turned your life around. Among the evidence, a judge will consider character letters from people who knows you, letters from former parole or probation officer, proof of employment or schooling, letter from employers, proof of work or accomplishment. 16. Attend the hearing if the district attorney decides that you meet the eligibility criteria, then she will schedule a hearing date and serve the notice of filing on the governor as well as the district attorney of each country in which you were convicted of a felony. You will also be notified. You should show up to the hearing early. This addressed as professionally as you can. You should expect the prosecutor who attempt to oppose your application. 6. Wait for the governor's decision whether you apply for a pardon directly or through the certificate of rehabilitation process. You must wait for the governor's decision. The governor has no published timetable for making a decision on pardon. The application is forwarded to the Board of Parole hearing for investigation. The board contacts the prosecutor and convicts victims for interviews. And if you have been convicted of more than one felony, the California Supreme Court must recommend the pardon if the governor can do so. Next to page 17 is something wrong. That's just the past. Page 17 is past. Page 18 is okay. Page 18. On the top, the same thing. Name and address, telephone number, everything is okay. People of State of California. People of State of California meaning California District Attorney. Defendant is client. Date of birth. Order for dismissal. Order for dismissal meaning accept expungements. The court to find from the record on file in this case and from the foregoing petition that the petitioner, the defendant in the above entitled criminal action, is eligible for the following requested relief. 1. The court grants the petition for reduction of a felony to a misdemeanor examination punishment of 364 days per penal code under Penal Code Section 17B, and for reduction of a misdemeanor to an infraction under Penal Code Section 17DE and reduced. All felony convictions in the above entitled action, all misdemeanor convictions in the above entitled action. The second one, mark the second one, all the misdemeanor conviction. Only the following conviction in the above entitled action. Specify charge, the date of convictions. 2. The court deny the petition for reduction of a felony to a misdemeanor under Penal Code Section 17B and or for reduction of a misdemeanor to an infraction under Penal Code Section 17D2 for just to check one. all felony conviction in the above entitled action? No. All misdemeanor convictions in the above entitled action marked here. Third one is all the following conviction in the above entitled action. No, just a pass. 3. The court grant the petition for dismissal regarding the following conviction under Penal Code 12034, 12034A, 12341, and then 2. And it's an order that the plea of guilty or no contenders or a convict of find the guilty be set aside and vacated and the plea of not guilty. Three, the court grant the petition or dismissal regarding the following conviction under Penal Code, something like that, and it's ordered that the plea of guilty or no contenders or verdicts or finding of guilty be set aside and vacated and the plea of not guilty be entered and that the complaint or information be and is hereby dismissed full. All convictions or plea for deferred entry of judgment in the above entitled action. Part 1. Only the following convictions or plea of deferred entry of judgment in the above entitled of Consequence 5. The court to deny the petition for dismissal under Code Section 1204, 120340, 120341, 120343, 120349, check 1. All convictions in the above entitled action. All the filing conviction or plea of deferred entry judgment in the above entitled action specify charge and date of conviction or plea for deferred entry of judgment. Page 19. 5. In granting the order under the provision of Penal Code Section 120349, the court to find that the petition was a victim of human trafficking when he or she committed the crime, the court order A. The relief described in section 12034. B. The relief described in section 12034 with the following exceptions. 6. If this order is granted under the provision of Penal Code Section 12034 or 12041, the petition is required to disclose the above conviction in response to any direct question contained in any questionnaire or application for public office or for licensure by any state or local agency or for contracting with the California State Lottery Commissioner and dismissal of the conviction does not automatically relieve petitioner from the requirement to register as a sex offender. Any sex offender we cannot request for expunging. A and B, that's the reason for dismiss the reason. 7. If the order is granted under the provisions of Penal Code Section 1203-49, the Department of Justice is hereby notified that petitioner was a victim of a human trafficking when he or she committed the crime and live over. This one is all of the reason for dismissal. 8. If the order is granted under the provision of either Penal Code Section 1203 or something like that, petitioner is released from the penalty and the disability resulting from the offense, except provide the Penal Code Section 29800 and 29900, formerly Section 12021 and 12021.1, and Vehicle Code Section 13555. In any subsequent prosecution of the petition for any offense, other offense, the prior conviction may be and provided praised and proved and shall have the same effect as if probation had not been granted of the accusation information dismissed. The dismissal does not permit person to own, possess, have in his or her control firearms if prevented by Penal Code Section 29800 or 29900, formerly Section 12021 and 12021, dismissal of a conviction does not permit a person prohibited from holding public office as a result of the conviction to hold public office. 9. In addition, as required by Penal Code Section 299, relief under Penal Code Section 17B, 17D2, 1204, 1203, something like that, does not release petitioner from their separate administrative duty to provide specimens, sample, or print imprints on the DNA and for forensic identification. Database and Data Bank Act. If a petitioner was found guilty by a trial of fact, not guilty by reason of insanity or plead no contest to a qualifying offense as defined not guilty or reason of insanity or plead no contest to a qualifying offense as defined Penal Code Section 296. The base for an order of a dismissal granted under the provisions of Penal Code Section 1203 1.43 is the invalidity of defendants prior plea due to this information in Penal Code section 1000.4 regarding the actual consequence making plea of successful completion of a default entry of judgment program. Date judicial officer. Judicial officer meaning judge or clerk. He signed. If he signed, send to this document, send back this order for dismissal.